Does bankruptcy affect a personal guarantee? Have you ever wondered what happens to a personal guarantee when bankruptcy comes into play? It's a common question, especially for business owners. Let's break it down so you can understand how these two concepts interact. A personal guarantee is a promise made by an individual to repay a loan if the primary borrower fails to do so. When you sign a personal guarantee, you are taking on personal responsibility for that debt. Now, if you find yourself in a situation where you need to file for personal bankruptcy, things can change. When you file for personal bankruptcy, you may be able to eliminate your obligation under a personal guarantee. This means you could be released from the responsibility of repaying that debt. However, this only applies if you are the one filing for bankruptcy. If your business files for bankruptcy but you do not, your personal guarantee remains intact. You would still be personally liable for that debt unless you also file for personal bankruptcy. It is important to note that not all debts can be discharged through bankruptcy. Some debts, like certain taxes or domestic support obligations, are considered non-dischargeable. This means that even if you file for bankruptcy, you may still be responsible for those specific debts. If a family member or friend for whom you have provided a personal guarantee files for bankruptcy, you are still on the hook for that debt. Their bankruptcy does not eliminate your responsibility. You would need to file your own personal bankruptcy to discharge your guarantee or have the debt repaid through a repayment plan. Another key point is that while bankruptcy can discharge personal guarantees, it does not automatically remove any liens or security interests a lender may have on your personal assets. If a lender has a lien on your property as collateral, they may still have the right to foreclose on that property, even after your bankruptcy discharge. However, bankruptcy may provide ways to challenge or avoid certain liens under specific circumstances. In summary, filing for personal bankruptcy is often necessary to discharge personal guarantees tied to business loans. If only the business files for bankruptcy, your personal assets remains at risk if you have guaranteed business debts. Consulting with a bankruptcy attorney is a wise step to understand your options and determine if your personal guarantee can be discharged.